Thank you for the kind introduction, and also thanks to the organizers for having us here. The title of the talk you find in the conference papers is probably a bit misleading because I won't give a thorough overview of the restitution since 1945, unless we want to be here until Monday. Rather, I'll address the transformation of historical restitution that we just heard about. So I'm very happy to come right after you because this is a perfectly fitting, I think. So I'll address the transformation of historical restitution into the present, namely in form of the Washington Principles of 1998, or rather their specific implementation in Germany. The process of dealing with looted art or Holocaust-era assets was seemingly completed in the mid-1960s. But as we all have heard during the conference, compensation remained a battlefield. In the 1990s, Nazi looted art was suddenly rediscovered in art galleries, museums, and also private collections. So the question of looted cultural goods, art, had to be renegotiated long after the registration deadlines for regular applications according to the West German restitution and compensation laws had ended. In a conference in Washington in 1998, 44 states pledged to return artworks confiscated by the Nazis and to find just and fair solutions. That's the wording, according to the so-called Washington Principles. The 44 signatory states found different ways to implement the principles, and as we also have heard yesterday, it was not always easy and still isn't. As in the past, the present-day questions of restitutions are contested grounds. In December 1999, and now I hope this idle words want with function, nice. So in December 1999, the Federal Republic of Germany laid the foundation for what is today known as the guidelines. The guidelines for implementing the statement by the federal government, the Länder, and the national associations of local authorities on the tracing and return of Nazi confiscated art, especially Jewish property. That's a title in English that is even more complicated than the German one. That's a first. A new version of these guidelines, the ones you see here in German, it's the Handreichung. And I will call it the Handreichung because inside the Handreichung, there's an Orientierungshilfe, which is also called guidelines. So it's a bit confusing, maybe only for me. So a new version of the guidelines was adopted in 2019, and that's a screenshot of the PDF you can see here. This text is the focal point of the project Law Without Law, or Recht ohne Recht, which I will present today. Recht ohne Recht started last year, so what I will talk about is an insight into work in progress. I, as one of two historians among legal expert and art and economic history, art market history experts, only started in January 2023. The Handreichung primarily aims at museums and public institutions, but also at private collection, and urges them to check their assets for potentially persecution-related pieces. Of course, it also aims at heirs and relatives of victims of the Holocaust. It is the document for said groups on how to deal with art and cultural goods looted by the Nazis, aiming at just and fair solutions between institutions, collectors, heirs of victims. The Federal Republic understands the Handreichung as a means to process the Nazi past. It's a part of the Aufarbeitung, if you want. Since 1999, a lot of provenance research has been set in motion, and the way the Washington Principles are implemented has become a field of research. The text of the Handreichung, with all its different parts, so the joint statement, die gemeinsame Erklärung, is part of the Handreichung, and also the Washington Principles itself. The text recurs to several criteria from the Allied and federal restitution and compensation laws from the 1940s and 1950s. So it's the Allied occupation era laws, it's the Bundesrückerstattungsgesetz and the Bundesentschädigungsgesetz, and some important decisions by the BGH and the Oberste Rückerstattungsgericht. So the text recurs to these compensation and restitution laws, and therefore the Handreichung contains an inherent tension. it effectively operates with legal terms, giving the impression to be a soft law, but specifically denies being any law at all. Nazi victims and their heirs do not have any legal claim against public institution in Germany if they suddenly discover that they have a lot of looted assets in their basements, which they forgot about the last 70 years. The federal government's 2021 to 2025 coalition agreement, so der gegenwärtige Koalitionsvertrag, seeks to improve the restitution of Nazi-looted cultural goods. But it is unclear whether this will actually result in the adoption of a restitution law, so a new restitution law. Even though there are proponents for a new restitution law. Even though these proponents of a new restitution law undoubtedly have weighty arguments on their side, possibly a new law cannot satisfy the expectations associated with juridification. The conflicts of the present do not result from any lack of legal clarity. They derive from differing interpretations of the facts. For this reason, it is much more important to systematically record and reflect on existing uncertainties than to enhance the legal status of this practice. The consequence of a legal regulation, and this is not meant as an offense to any lawyers and people who are active in the law, the consequence of a legal regulation would probably not be initially to provide a clearer definition of what is a just and fair solution, but mainly to put the responsibility in the hands of lawyers. The involvement of legal representation has indeed become necessary on many occasions in the last 20 years. There are several lawsuits at the moment in the US. So it has become a focal point for struggles and quarrels, even without there being any legal basis. Furthermore, operating with legal terms from the 1950s and 1960s, as the Handreichung does, means to import the legal problems of the Cold War era. Also, some new restitution cases were accompanied by anti-Semitism, which in its structure had some similarities with the anti-Semitism that was very evident in public debates around restitution, Wiedergutmachung in the 1950s and 1960s. We don't have enough time, but I could show you some examples. And there are very clear statements by German officials in West Germany who were responsible for Wiedergutmachung. I mean, Konstantin Goschler can say more about this than I can, that are like clearly anti-Semitic. So much for a brief introduction. In the following, I will first give a quick overview of our project. I will then present exemplary problematic terms of the Handreichung, or terms that can possibly be interpreted differently, and that affect attempts to mediate fair and just solution in restitution cases. After that, I'll show you briefly how and why 1950s restitution criteria and discourse are highly sensitive. Of course, you know that, but their possible influence on modern restitution cases should be carefully considered. So the project is based at the Chair of Civil Law and Modern Legal History at the Europa-Universität Viadrina in Frankfurt, Oder, and is supported by the Stiftung Erinnerung, Verantwortung und Zukunft, the EVZ, you all know it, Remembrance, Responsibility and Future, and of course the Federal Ministry of Finance. What's our goal? Our goal is an interdisciplinary legal commentary on the test criteria of the Handreichung. The project chooses this legal method of a legal commentary. We just saw a quotation from a legal commentary from Van Damme and Loos of the Bundesentschädigungsgesetz. Commentaries are, I'm not a lawyer and I'm a historian, so but they are super important apparently. And the project chooses the legal method of the law commentary, but expands it in interdisciplinary way. That's why I'm here. Only the systematic combination of legal history, art market, and economic history, and law studies, and allows for comprehensive scientific evaluation. Yeah. Yeah. This is how a typical commentary looks like. How are we going to implement our project? The first step, and I think that's the step we are in right now, is a thorough analysis of the guidelines, the Handreichung's basic terminology. Then we will examine the principles practiced in the post-war period, so the historical restitution and compensation, and their afterlife, and trace their afterlife in the Handreichung to achieve a better understanding of unclear or uncertain sections. Then we'll have a systematic collection of these unclear sections in the Handreichung from a legal point of view. And of course, this won't be possible without an evaluation of research on historical jurisprudence, art market research, and the Holocaust and its aftermath. What are the planned results? Of course, I said it, the publication of a legal commentary and the implementation of an education program to sensitize actors in the field of provenance research and restitution. Because there's, in provenance research, there's often, there's a big gap between people who do provenance research and the people who do research on Wiedergutmachung and so on and so forth. So we have to build a historic understanding. I'm coming to the problems of the Handreichung. Maybe the key problem is the transformation of the historical into the present. To identify art or cultural goods robbed by the Nazis, the Handreichung refers to a historical instrument or several historical instruments. I said it, it's the Allied Restitution Law of 1947, so for the Western zones of occupation, the Federal Compensation Act, and the Bundesrückerstattungsgesetz, the Federal Restitution Act. This seems to be the key problem. According to the 1947 law, any sale conducted, art sales, any sale conducted by a Jewish person between 1933 and 1945 was automatically counted as a forced transaction as long as the buyer could not prove that the sale had been voluntary and met some more criteria. And one of the criteria was the free to dispose. I called it here freie Verfügbarkeit, unhindered disposition. I found different translations. So free to dispose is the one you'll find in the English version of the Handreichung, and freie Verfügbarkeit is the German term. The freie Verfügbarkeit, unhindered disposition, was and is an important indicator for the identification of persecution-related loss of assets. It seems clear if you read it, and if you're not a legal expert, it seems clear a persecutee who sold an item but could still freely dispose of the money was unhindered. In German law, however, in a historical restitution, in a German law, not being able to freely dispose of something is only the case when someone is hindered by legal means. In historical restitution practice, this only included Nazi-era transactions after which the proceeds went to a blocked bank account, a Sperrkonto. The seller, a persecuted Jew, was legally hindered to access the money. Many other cases met the criteria of unhindered disposition. The implementation of the 1935 race laws played a role in historical restitution as well. There were some set dates after which any sale was understood as involuntary. So this is some dates in 1938, and especially the implementation of the race laws. But as we know from Holocaust history, there can be extra-legal terror. There can be SA terror in 1933. So as a result, the extra-legal SA terror that drove many into selling their assets long before September 1935 was not necessarily seen as a legal hindrance in historical restitution. At least it's legally possible to say, okay, you can freely access your money. Cynically speaking, no one was legally bound to escape. Of course, a modern, historically sensitive interpretation would understand this differently. Awareness about the historical origins and the possibility of a strictly legal interpretation of such terms should accompany the Handreichung, as well as a possible new law. Because if we just take these terms and transfer them into our age, The second thing is I would just quickly gloss over it. It's the Prioritätsprinzip, priority principle. And just as we heard, this is also based on a legal principle borrowed from German, I think, civil law as well. So in the 1950s, there were always restitution procedures in which two injured parties or two aggrieved parties claimed the same item, because many things between 1933 and 1945 changed hands many times. Let's say a German Jew decided to flee in 1935 and sold his art collection to finance immigration. For us, from a nowadays like an ethical or perspective, that's a clear case of persecution-related loss. Let's say the buyer was also a German Jew who still believed in 1935 that, yeah, maybe I was a World War I veteran, I will survive this. And this Jew who sold the item from another Jew is then murdered, looted, and killed in 1942. Undoubtedly also a case of persecution-related loss. The jurisprudence of the 1950s, however, solved this dilemma by resorting to German property law. And from property law, the priority principle is borrowed. From two dispossession orders, only the first is effective. And of two Nazi victims, only one can make the claim. Sorry, guys, only one. Namely, the first aggrieved individual. Today, more than 70 years after the defeat of Nazi Germany, parts of the chain of provenance can often no longer be elucidated. The Handreichung advises to trace the provenance back to January 1933, which makes a lot of sense. By referring to the historical jurisprudence of German restitution laws of the 1950s, however, the Handreichung could be interpreted as to indirectly advise to apply the priority principle of German property law, which in no way reflects the Shoah. Yeah? Holders of cultural goods suspected to be Nazi looted could possibly refuse restitution if they argue that, even though a compulsory sale has undoubtedly taken place, the existence of an initially aggrieved party cannot be ruled out. Fearing to ignore an unknown and often hypothetical Jewish fate, the Handreichung could be interpreted as to favor early persecution-related loss over a later one, which often means escape above death. Here, the transformation of 1950s jurisprudence into the 21st century Handreichung is unclear, and it raises the question, in the sense of the washing principles, if that's fair and just. There are a few more problems from my historical point of view with the Handreichung. The two aspects I mentioned are just two sensitive, like legal aspects. There are many more that go beyond the narrow focus of the commentary we want to write, but they're still interesting to our project as a broader context. Just to name a few unclear sections of the Handreichung, I won't go into details. According to the Handreichung, restitution has been generally finished and there is no legal claim to it anymore, except in the former GDR, but that's a different case. This clearly omits the exclusion of many marginalized victim groups who were only acknowledged much, much later, if at all. Roma and Sinti, asocials, homosexuals, lesbian women, and yeah, of course, also gender non-conforming people persecuted as gay or as asocial. To avoid, and there are a few more, but I won't go into detail now. So for me, the definition, what is it about art? Is it about cultural goods? That's not clear. And do we only talk about art? What about lost items of moral value, everyday items? What's the role of the bystanders? If you read the Handreichung as well as the historical restitution, you feel like there's the state and there's the individual. So there is no reflection that the Holocaust was yeah, a collaborative crime committed by the whole German society. And this, there's the phenomenon of the Aufbewahrer, people who took their Jewish neighbors' stuff and then didn't give it back afterwards or made a business with it. This we don't find that reflected. To avoid double compensation, as the Handreichung calls it, the Handreichung has like kind of exclusionary or einschränkend, I don't know the word right now, limiting sections that deal with restitution cases that already ended with a settlement in the 1950s and 60s. This would, it's not really an exclusionary clause, but we will come to this. So even if Nazi looted cultural goods resurfaced today, if the federal authorities already paid restitution, like in the 50s or in the 60s, because back then the piece of art or the cultural good couldn't be fined, so restitution has a monetary compensation because the actual good cannot be restituted. If that was the case in the 1950s and the piece of art resurfaces now, the sum that the federal authorities paid in the 1950s has to be paid back before the resurfaced piece can be restituted to the heirs of the persecutee. This omits, from my historical point of view, how historical West German jurisprudence distorted the Nazi past with what I call legal fiction in my dissertation on alleged Jewish collaborators in post-National Socialist Germany. The GDR did the same, but in a different way. In 1950s, East and West Germany, alleged Jewish collaborators, traitors, people who made reports at the Gestapo under torture, were treated worse than the Gestapo officers who did that on purpose. Reparations, and one theater of discussion who was an honorable victim and who was a traitor was, of course, restitution, compensation, and applications for becoming a victim of fascism or for des Faschismus. Exclusionary clauses in the Bundesentschädigungsgesetz and Opferanerkennung, applications for victims of fascism, had exclusionary clauses, and these clauses moved victims to alter their stories. Primo Levi's gray zone, struggling for survival at the expense of others, had no place in early restitutions, of course. There was no place for any gray zones, for any ambiguities. Reading hundreds of compensation and restitution files, I argue settlements were often, as a Vergleich, settlements were often disadvantages for the victims, but they agreed for several reasons. I'm coming to my end. I will just give you a quick example of this. Kurt Naumann was a Jew from Berlin. He survived the Shoah after his arrest and hiding in late 1943 by working as an odd job man in the Berlin Gestapo assembly camp. He was hated by some as a collaborator because he was the Jew errand boy of the Gestapo, but others depict him as the savior. And there is historical evidence that he probably hindered a massacre of the Berlin Gestapo and SS at the last days of the Battle of Berlin. As the only surviving member of his family, he tried to get back in a 1950s restitution trial, jewelry and art robbed from his house during a Gestapo raid. He brought 3 witnesses who testified in his favor, a representative of the Berlin Finance Senate, standing in for the former Nazi authorities and keen to minimize the cost of restitution, tried to avoid being held reliable and commented the description of the witnesses in 1956. At the very most, I quote, "It emerges from the testimony that Gestapo officer Hansen, who played a very strange role, personally took possession of these jewelry items and took them away. Based on the testimony of the witness K, it would thus be proven that the taking away of the jewelry must have been a so-called wild action. According to the witness's account, the German Reich, which I represent, never gained possession of these items. It follows from this that the German Reich cannot be called upon to pay damages," end of quote. Following this argument, the restitution court rejected Kurt Naumann's claim after years of legal battle in 1962. Thus, the specifics of the law demanding proof that items had to have come into possession of the Reich allowed the successor organizations of the Nazi profiteers to successfully turn the reality upside down. Armed robbery by state actors carrying out the Führer's will was declared an act of personal enrichment without connection to the state-governed persecution. Gestapo officer Hansen was tried in an internal SS trial for his corruption. So all the things he robbed from Jews came into possession of the Nazi state with high probability. Decisions like this created an alternative reality of the Nazi past to the disadvantage of the victims, coercing them to agree to disadvantageous settlements. And this is not the only social factor. Many persecutees were sick, they were impoverished from the persecution and in desperate need of financial liquidity to emigrate or start over, and confronted with German authorities keen on beating down the price, former persecutees were likely to agree to disadvantageous settlements. I said it. We all know about these problems of Wiedergutmachung. So I picked this example to specifically show that keeping settlements as a kind of limiting factor in the present-day Handreichung, or even a new restitution law, if it would ever come to pass, would possibly perpetuate such, from my point of view, unjust constellations. To sum up, the attempt to process the Nazi past with fair and just solution, as suggested by the Handreichung, seems to be in danger to be thwarted in some cases by the transformation of the past into the present in terms of legal elements. And our practical commentary aims to shed more light on this. Thank you.